afternoon. Teresa Phillips here from Forster Bowman. Thank you for joining us as we continue to explore senior citizen and elderly exploitation issues. Today we're going to take a little bit closer look in this series we've been doing at what legal protections you actually do have when it comes to exploitation. We're going to go a little bit beyond what we discussed last time. And then we're, as always, we're going to try to give you some helpful hints to avoid these kind of situations, the latest on some scams, and some resources for you and or your clients who may be dealing with these type of issues or want to prevent these type of issues in the future. So let's see what our agenda is going to be today. First, we're going to recap the part one of the series, and that area we went over specific statutes under Florida law that have been designed to protect and give remedies to folks who've been victims of elderly exploitation. We're going to do just a short recap and see how that leads in today, where we're trying to delve into more real practical ways to protect yourself or be remedied if something should happen. And then part two, we're going to start looking at how third parties can be liable, not just the perpetrator, but other parties who may have assisted somehow in the perpetrator being able to commit the fraud or the exploitation. The third section is going to be prevention. We're going to look at some examples of how people have been affected in our own area here in Florida, and we're going to give you some guidelines, some lists to go over with your elderly clients or your elderly persons that are in your life, things you might want to look at and questions you may want to ask. And as always, give you some advice on trying to prevent this and doing some pre-planning. And then as always, we'll conclude with some opportunity to pose questions. So let's get started. So what you might ask, why are we having a whole series here on these kind of things? Well, you know, the elderly population, seniors who are defined as 60 and over under Florida statute, that's more than 5 million residents of Florida. So Florida, probably more so than any other state, has a vested interest in protecting elderly from exploitation and abuse, primarily because they make up such a big part of our community, and they could be so easily targeted here in our state if there weren't certain protections and extra events and statutes and all kind of things to look out for them. So I think Florida's moving in a great direction in that sense. If you're not aware, just in 2019, the Florida State Attorney General actually came up with a whole task force to address elderly exploitation and see what more we could do in the state to protect the elderly population. It's called the Seniors Protections Team. It's dynamic. It's created and comprised of a whole bunch of individuals from different agencies, and also lawyers and investigators. And I think it's again a sign of that Florida is being proactive and being aggressive and trying to keep this this booming part of crime and fraud that's targeted to elderly persons out of our state, and trying to limit that. And I think that's all those things are very good. And here at Forster Bowman, we're committed to trying to keep people as informed on these developments as possible. So let's recap from part one so that we can get through what we're going to look at today, and then we'll talk about what things we're going to look at our final part of the series, part three. So previously on part one, we looked at the law related to elderly exploitation, and we reviewed chapters 415 and 825 Florida statutes primarily, and discovered what constitutes elderly exploitation, both physical and financial. We looked at who's considered an elderly or vulnerable person under the statute. We looked at what kind of persons can form a relationship that causes them to be subject to criminal penalties or civil penalties if they take advantage of that relationship they have with the elderly person and exploit them financially. Remember, under section 415.1111 Florida statutes, a plaintiff is entitled to actual damages and punitive damages as punishment to the wrongdoers and as a deterrent from other similar conduct. under Section 772.11, which is what provides the civil remedy for violating 825.03, the damages can be 3 times the amount, treble damages, as a punishment for taking on this kind of action against an elderly person. We also looked at criminal penalties against the perpetrators of the exploitation. Most of those were felonies. We also discovered a statutory duty to report elderly exploitation, and there were specific persons that applies to. Section 415.1034 Florida statutes has mandatory reporting of abuse, neglect, or exploitation of vulnerable adults, and other mandatory reporting. Those persons who are required to report include, but are not limited to, physicians, and then there's medical examiners, chiropractors, physicians, nurse, paramedics, emergency medical technician, or hospital personnel engaged in the admission, examination, care, or treatment of vulnerable adults. And then number 2 says health professional or mental health professionals other than ones listed in subparagraph 1. I think between those 2 subparagraphs, if you're involved in the medical industry and treating or even admitting patients in, you're probably going to fall under this category, and you have a duty to report. Number 3, practitioner who relies solely on spiritual means for healing. Again, that's probably someone would fall under that medical sort of list of persons who fall under the mandatory reporting statute here. 4, nursing home staff, assisted living facility staff, adult daycare centers, adult family care home staff, social worker, or other professional adult care residential or institutional staff. That's a pretty broad category, and is intended obviously to cover most services that elderly folks may come in contact with, who may be taking care of them and may be taking care of a vulnerable elderly person. Number 5, state, county, or municipal criminal justice employee or law enforcement officer. 6, employee of the Department of Business and Professional Regulation conducting inspections of public lodging establishments. So if someone's out there inspecting and they come across an assisted living facility or something that's statewide, like Medicare, Medicaid run facilities, and they see any kind of exploitation or abuse going on there, they have to report, even though that's not really under their purview normally. Number 7, Florida Advocacy Council or Disability Rights Florida member or representative of the state long-term care ombudsman program. That's the program that investigates and regulates assisted living care facilities and nursing homes. So if someone in the course of their duties in administering these programs, if they come across something, they have to report it as well. Bank, saving, and loan or credit union officer, trustee, or employee, and that's going to be a big one that we look at today. Just go back real quick, why the bank, savings, and loan or credit union officer, trustee, or employee is a really big deal. Is prior to this statute and other similar statutes being adopted in other states, the general rule was that banks and similar institutions had absolutely no duty to report, even look out for, or protect their bank members from negligence. They had a duty of ordinary care, and generally speaking, that didn't include looking out for these kind of things or trying to stop these kind of things that we're talking about today. In fact, the UCC had a specific provision that exempted them, or seemed to exempt them from any kind of liability like that, or exempt them from having a duty to do that. But now, with these statutes being passed, now the law is shifting to where it recognizes a duty in certain cases, and we'll look a little bit more closely at that today. What you might have missed, though, in that reporting statute is there's no private civil cause of action under that statute if a third party fails to prevent, detect, or report suspected financial abuse. There was only a criminal penalty, and that criminal penalty was a misdemeanor. A person who knowingly and willfully fails to report a case of known or suspected abuse, neglect, or exploitation of a vulnerable adult, or who knowingly and willfully prevents another person from doing so, commits a misdemeanor of the 2nd degree. So what's happened is people think that maybe that doesn't have as much teeth as it has. I mean, a misdemeanor is obviously a serious offense, but certainly not as serious as a felony. Certainly when you look into the realities of our local state attorneys going to actually prosecute these kind of things, and how much does it really help the person that's been exploited if they have have lost their money, and they are looking for people who maybe could have prevented this from happening. So this all is going to wrap up together in what we're going to discuss in more detail today. And that's going to be third-party liability, our second part. And what I want to look at today is a more practical aspect. We looked at the statutes. We found out when people commit these kind of crimes and acts, they can be criminally liable. They can be forced to pay back the money plus be penalized for any other damages they caused. They can be exposed to punitive damages and treble damages. They can be exposed to attorney's fees. All those things, which, on paper sounds really good, but here's the reality of the situation. Many times these scammers, perpetrators, the money's gone, or they're gone. And, and they essentially elude any kind of repercussions, and certainly no repercussions that actually help or benefit the exploited person. Even in a criminal proceeding, if the money's already been spent or sent outside the jurisdiction of the court, or where it can't be recovered, the criminal proceedings can impose criminal penalties, which can include restitution, but how is the person going to pay it back? And the reality as an elderly person in those kind of situations, oftentimes, even if there was a financial recovery, either civilly or criminally, they'll never actually see the money. So then it begs the question, when there's other people that were involved that could have prevented it, had a duty to prevent it, can the person look to them? And oftentimes those are going to be people like I listed here. And as we go through today's seminar, I want you to think of these kind of people in these scenarios who might not be the perpetrators themselves, but how they might become liable. And this is important to understand from the perspective of the person who might be exploited, but also if you represent the interest or are one of these people too. Think about how you can become involved if you fall under one of these categories in an exploitation liability suit, even though you didn't actually participate in the exploitation directly. So I want to go through this list, and we're going to come back to this list after our discussion to see how we can understand better how liability might get extended to these people and these institutions listed in certain situations. So let's consider bank employees, financial advisors, accountants, relatives, assisted living employee, fiduciary, fiduciaries, i.e. like a trustee or a guardian, and physicians. Again, we're looking at third parties, not the person that actually exploited, but third parties that might be relative to the exploitation. First thing you might ask yourself, why would a third party not report? Section 4.15.111 Florida statute specifically grants immunity from liability as long as a reporter is acting in good faith. Grants immunity from liability as long as you're acting in good faith. But so why wouldn't someone report? These are the situations that I've read in case laws or from individuals who were involved. One, there's a natural inclination to sometimes that people don't want to get involved, and they don't want to report things just because they don't want to be involved. They don't want to have their name given to an investigator or to the police, and they'd rather just stay out of it. I think Florida law is becoming very clear and pretty explicit that many of us have a duty to report now, and a duty to prevent. And so if you're one of the people who fell under that category that we looked at of people who have a duty to report, and remember, it wasn't limited to that list. It says a list of, but not limited to. And then look at the people that I had mentioned to before, who I think are a good list of people who would be coming in contact with an elderly person who's being exploited or abused, and may have an opportunity to prevent it. When you look at all those things, you're looking at a whole group of people that might prevent this, and I think the law is becoming more and more clear that they're trying to target these kind of groups of people and impose a duty to do this. So what's some other reason why they might not report? There previously in some of the older law, especially before these statutes, Judges would take issue with banks who refused to deal with persons they thought might be incapacitated or might be being taken advantage of. And there was oftentimes in dicta, at least some discussion that that's not really the bank's place, that their obligations to do what their member tells them to do. That's their contractual obligation. And per the UCC, they don't have any other duty than that. That was kind of the old guard way. Like I said, there's a trend now getting away from that. And third, I think there's still parties that are worried about liability if they do report, if it turns out to be false. These are just suspicions. Maybe they're reasonable on their face, but maybe there's a reasonable explanation when someone investigates. Will they be sued for defamation or slander or some kind of tortious interference or some other claim if they report? I think if you remember, we looked in Series 1 that there are actually damages if you make a false report. You can be criminally charged. But I think that's when you have to test what is good faith. And if a reasonable person would believe that there's suspected abuse under the circumstances, if you have no other motive, if you're not, if you have no other nefarious motive, i.e. bad faith, then I think that this section is designed to give you to make you feel free to make that report. And like I said, granting immunity from liability is a pretty strong statement. So I think a lot of times people just need to be educated. And I think some of these parties that we're looking at, these third parties, they're in the middle of a shift that where they're educating their employees, they're educating themselves, they're coming up with procedures, and so that they can determine when they have a duty to report and put all their ducks in a row so that they have the good faith defense if something doesn't come about or there actually was an abuse even though they reported it. So under what theories are we getting third-party liability? Well, the number one that I see in the few cases that have been successful, the claim is under a negligence or breach of duty kind of claim. There's no specific statute permitting recovery from a banking institution under Florida law in circumstances of elderly exploitation. In fact, banks are oftentimes specifically excluded out of abuse statutes and things of this sort. I mentioned the UCC code previously as an example. When you really start seeing the switch among the judges is one of the key moments I thought was in this case. It's not reported. It's actually just a local decision, the local Middle District of Florida Federal Court. But in 2013, Walther versus McIntosh, I think between 2013, we're going to look at this case, and then a case that came out in 2015. I think you're going to start seeing the shift in the judge's analysis. In 2013, Walter and McIntosh actually reiterated what had been pretty much the standard law, that while a person such as a trustee may have a duty to report, the sole remedy is criminal. And in this case, they dismissed the complaint that sought relief under the Chapter 415 for failing to report. Now, we're going to look at that had been the standard line, but then I think practitioners got more creative and started using the statute in a different way. They started using it as a basis for negligence claims, and then these cases started getting some traction. Let's look at the 2015 case I mentioned. In Skinner versus Bank of America. Again, it's not a reported case. It was 2015. It came out as a local decision from the exact same court that we just looked at, the Middle District of Florida, Orlando Division. And it started giving some hope that the Florida law does in fact recognize a cause of action that can hold negligent banks responsible when they fail to report and prevent. In this case, these were the facts. We have an 81-year-old woman. She held her life savings of about $175,000 in various accounts at Bank of America. In 2013, an individual falsely identifying themselves as a BOA employee convinced the elderly woman to transfer almost all of her money to other parties. During the few months it took for substantially all of her money to be diverted, Bank of America posted multiple suspicious activity reports on her accounts and was even informed by her daughter that they should be on the lookout for fraudulent activity. And despite this, Bank of America did nothing to stop the transfers and made no report to the authorities or DCF. So she sued on 3 different counts. 1, common law negligence. 2, breach of Chapter 825 and 3, breach of Chapter 415. The 2 statutory causes of actions under the 2 chapters there, they were dismissed, just like had been common during these lines of cases, because there was no civil remedy for failure to report or prevent, even though there was certainly a duty and there was criminal penalties if a local state's attorney was willing to actually prosecute. But the common law negligence case held up, and the court's reasoning gives a legal basis for Florida victims going forward, wherein a mandatory reporter fails to act. And we're going to look carefully at that reasoning, because I think it can be used to argue that it goes beyond banks. So let's remember what common law negligence is. To state a claim for negligence, a plaintiff must allege the defendant owed a duty of reasonable care to the plaintiff, the defendant breached that duty, and the plaintiff suffered damages as a result. Why negligence had previously always failed when used was that there was no duty of reasonable care to the plaintiff, or at least that's what the courts were finding. But now, by 2015, we have the statute, and it had been around at that time, but it had been beat up. There was a whole another adoption in 2015, and I believe that's also a time when elderly exploitation and abuse was beginning to get more headlines and becoming more of a focus in the legislature branch. And so at some point we have a court here recognizing that duty. And as it states here, the duty element of negligence is a threshold legal question, because if no legal duty exists, then no action for negligence can lie. And generally, there is no common law duty to prevent the misconduct of third parties. However, a legal duty may arise from legislation, case law, or the general facts of the case. Florida courts do allow the showing of a statutory violation to establish the existence of a duty and a breach thereof. So the court took these general principles of negligence law, and then they looked at the statutes that had been cited and determined if they could come up with a basis to say that banks do have a reasonable duty of care to act and report and to prevent these kind of things. So here's the court's reasoning. Even if the court were not to look to the act in answering the question of duty, the court finds that the general facts of this case warrant the reasonable inference that Bank of America breached a duty of care to plaintiff. A duty may arise whenever an actor recognizes that his conduct involves a risk of harm to another. That comes from an Old Bridge Statement of Torts. So the ability of the actor to recognize that his conduct creates a risk of harm is judged according to a reasonableness standard, or if the actor exhibits superior attention, perception, memory, knowledge, intelligence, and judgment, then his ability is adjudged to those superior abilities. Now, why I think this is important, I'm going to pause here in the reasoning, is the superior attention, perception, things of that sort. The court recognized in the opinion that banks, they actually have programs and procedures in place to identify potential fraud, unusual activity. They do, and that's what happened in this case, but they do that as a matter of course now. They have the resources, they have the computer programs, they have the software, they have the reviewing transactions that they can immediately know when things look suspect. Something that, laypersons, even the elderly person might not have the ability to really see see the bigger picture of what's going on in their accounts like Bank of America can. Okay, so the court continued to reason. Bank of America undertook the task of discovering the fraudulent activity perpetrated against plaintiff, but failed to notify plaintiff or to take any other action to protect against the fraudulent activity, despite BOA's knowledge. Further, it is reasonable to infer that Bank of America, acting as plaintiff's financial institution, had superior attention, perception, knowledge, intelligence, and judgment in recognizing the risk of not notifying plaintiff or of potentially fraudulent activity, or failing to act to prevent future fraudulent activity, especially in light of Bank of America's numerous suspicious activity reports. Accordingly, the court is able to reasonably infer under the circumstances of this case that Bank of America created in itself a duty of care to plaintiff upon learning of her exploitation, and breached that duty by failing to notify plaintiff of its investigations and by failing to act to prevent future fraud despite its knowledge thereof. So let's go back to that. So what we have here is that the court looking at in cases where You have superior knowledge, perception, intelligence, attention, and judgment in recognizing risk, like Bank of America had here, you can be, there can be a reasonable inference of a duty of care. I think that's important because I think that can go in other directions. That can apply to other folks other than banks, especially in today's computer age and digital age. Now, banks, financial institutions, they were already in the business of detecting suspicious activity at this time. Not maybe necessarily to protect elderly persons, but to protect themselves. They don't want to be on the hook for fraudulent activity. They want to make sure that they don't end up taking the liability on a fraudulent transfer or fraudulent transaction. But that same technology gives them an ability to see, hey, this is unusual. Maybe it's not fraudulent in the sense that that's actually the signature of the bank account owner, or they use their card and their PIN number to make the transaction, but this huge number of transactions is completely unusual, and they can see things that are suspicious that maybe wasn't the intended purpose of monitoring these accounts, but they've gained that kind of knowledge. They've kind of gained that perception and attention. And the court here says once you've done that, then you have a duty of reasonable care. So what happened in this case? Actually, the judge dismissed the motion to dismiss, said you're going to court because you have a duty of care, and the trier of fact will determine if you breach that duty of care, and it's settled. So we didn't get a final resolution, didn't get that appealed up where we have a reporting opinion on this, but I think this is very good analysis. I think it does kind of showcase a new day in the law and a new willingness to hold third parties liable in these kind of cases. So let's look at some other things, how third parties can be liable. Insurance. Sometimes I think people forget about insurance. Let's say you've had someone's exploited you, but they ran off with the money. No one knows where they are. Look at the situation and see if maybe there's some insurance that can be involved. Some of the common ones that might come into play are professional malpractice insurance. This would come into play if the person that did the exploitation was or an employee of, say, like an attorney or an accountant. That's also how errors and omissions can come into play. Your accountants, your caregivers might have errors and omissions. Maybe someone who was a notary who notarized something and shouldn't have, because the elderly person clearly, wasn't aware of what they were reading, or that even the elderly person wasn't there, the proper witnesses weren't there. They have errors and omission insurance oftentimes. There's employee defalcation insurance and bonds oftentimes in place, especially for things like caregivers, people that deal with elderly persons. They're oftentimes required to have that insurance or their employer has that insurance. A lot of employers will have insurance that will cover criminal activities that may be perpetrated by their employees and things like that too. So when you look at this, look at the other third parties involved. What were their relationships? How did they get in touch with you? How did they become part of your lives? And determine if they have any kind of insurance that may pay out a claim on this. Third, I didn't list here, but also, and it's probably a little too detailed and it's complex to go into too much today, but for my practitioners out there, or people who are looking at a case right now and they're trying to think of laws that might could help them, I encourage you to look at the ADA, the American with Disabilities Act. It would depend on the circumstances, but you can imagine maybe a case where someone comes into a bank and they're blind and they're dependent on someone else who's reading things to them, or they're really controlling the situation, and the person may be saying yes to the bank employee, but you don't know what they've read, that you don't know what they've understood. There could be an argument that a bank has a duty to maybe provide readers or a way for the blind person to read that on their own without the assistance of someone else that might be put in a position to exploit that role. There's a few examples, if you were creative enough, that you could probably think of that maybe it could have been prevented if the provider of the service had provided some kind of ADA compliant accommodation. So I think that might be an area ripe for fodder in the future. So now that we've looked at some different things, let's go back to that list I had, and now we can kind of analyze and look how maybe third parties would come into play. And again, we're looking at the situation where you can't just go back and get your money. The person's taken it, it's gone, maybe they're gone, that kind of thing. So you're looking at other ways that maybe you can get compensated or reimbursed for how you've been damaged. We looked at a specific case in Gander about bank employees. And I think that's why you're seeing banks now, they have training, they have procedures. When they suspect, most bank employees now are told to make certain reports to either the authorities or DCF or Adult Protective Services, and then take action to prevent and put stoppage on the accounts, or call to get extra verification, things of that sort. Let's think about financial advisors. They don't fall under that category of necessarily having to report, especially if they're not associated with a bank and things of that sort. But why I want to list them here is I do think they fall squarely in that analysis that we looked at from Ginder, that they have the superior knowledge, perception, information, where they could see suspicious fraudulent activity. I think financial advisors have to ask themselves, or have they obtained enough information, taken to obtain this information, and could they one day, could a court say, you now have a reasonable duty of care to report and prevent these kind of situations when this kind of information becomes known to you. Accountants, similarly, they have access to information depending on their role, whether it's overseeing transactions, essentially bookkeeping functions or tax functions and things of that sort, or giving tax advice. They certainly can probably come across situations that they would cause them to suspect elderly exploitation, and because of what they have and their knowledge, and probably part of their duties, probably to find suspicious activity, because that can have taxable consequences and things. Could you see a court one day using similar analysis to say an accountant in this case has a duty to a reasonable care and has a duty to prevent and report. Relatives, relatives can be mandatory reporters in certain cases, and they certainly fall under a category of common exploiters in these situations. But can a relative have gained so much knowledge, they took over the bookkeeping, they took over paying the bills, they took over the role of overseeing the person's bank accounts, or directing finances and things, and they see someone coming in and perpetrating a fraud, and they just keep their mouth shut? Can they be liable? Can they be deemed to be so compliant, even though they have all this knowledge and everything, that they can be deemed negligent? An assisted living employee, and this is any kind of senior living kind of situation, there's always employees. Is there a situation now where you can see such an employee who has a duty to report? Can you see a court now applying the same reasoning, saying, well, in this case, you have a duty to report. The statute creates a duty, and because you didn't report, you're now liable. And of course, now would that vicariously, lead to the assisted living facility being liable for that due to the employee's negligence? The fiduciary, the trustee, the guardian. In these cases, they may have bonds. Remember, we looked at the bonds and insurance earlier. Trustees, sometimes those are waived. I'd say more times than not, most people who create trust waive those provisions to have bond. Guardians almost always have bonds, especially in Florida. I can't think of a situation where they don't. The law provides that they have to have bonds to protect. Professional trustees certainly would probably have the resources to repay, and again, they can be mandatory reporters, and therefore by the extension maybe have a statutory duty. Again, I think fiduciary duties too. Fiduciaries also have that superior knowledge, perception kind of thing going on that we looked at in Ginder, that you could use that argument to say that they've committed negligence if they haven't reported insured exploitation that they see through their roles as trustee or guardian. Finally, look at physicians. I think physicians certainly can see physical abuse. Can they see financial exploitation? Can they see a difference in someone that they've been treating for a long time? Can they see a difference in maybe their financial situation? I don't know. I don't. It would depend, I think, on the relationship that physician has. I mean, like I said, I doubt one trip to the ER that the physician would be able to ascertain enough information to determine that there's financial exploitation going on, unless the person just told them that. But if it's a physician-patient relationship that's been going on for many years, and you see a change in behavior, a change in financial status, change in the people that come with them, or system, maybe see a dynamic there that seems concerning, maybe the physician that does rise to the level of having a reasonable suspicion and a duty to report, and by extension, third-party liability, perhaps, if you don't report. So I hope that helped going through this exercise to see how we looked through these things and then came back and looked how we maybe different people that might be involved in the perpetrating of a exploitative event or fraud on an elderly person might be held liable in the event, especially in an event where the perpetrator themselves can't be found or can't be located or the assets can't be located, and there's no way to recover in a practical sense. So let's move to number 3 parts of our agenda today. Prevention. This is something that I'm dedicated to, our firm's dedicated to here. I think you're seeing the state of Florida is dedicated to it, and a lot of it comes from knowledge and education, and keeping yourself educated about the latest scams. And believe me, they are dynamic, and they are everly getting more creative, and Florida is definitely a target. Definitely communities where there's elderly or more than average elderly populations tend to be targeted. The Villages, a local institution around here that most people are familiar with in Central Florida, it's often targeted, and its members and residents are targeted. And let's look a little bit at those scams. Let's look at some cautionary tales, and let's educate ourselves on how maybe we can prevent that. So what are some of the latest scams? I'll give you a preview of what our next scam alert is going to be on our ForsterBowman.com website. We try to post there every so often and keep people up to date on some of the latest scams that are being reported either through the Florida Attorney General's office or through local news or other resources. And I'll give you a preview. One of the latest for our next post, but one of those is a charity scam. It's been around for a while, but there's always developing new angles, and oftentimes elderly folks are targeted by what appears to be legitimate charities, veterans groups, Meals on Wheels, Christmas, children, toys for Christmas for children, anything that would sing to the heart of elderly folks, and they seem legit. They seem to have credentials. They will know your number, your name. They may even cite where they received your number, maybe because you donated somewhere else. But they may very well be a scam. And like a lot of scams, you need to be suspicious. If someone calls you that you don't know, no matter how well they present themselves, always be suspicious and ask questions and take down information. Ask for things like tax ID number. That's something they should have readily available if they're a charity, because a lot of people like to take a deduction, and you can use that tax ID number to look them up and see if they're legit. Take down their name. You can, and then you can do some research and determine if they're legit. Ask for an individual's name. Ask them where they operate from, and ask very specific questions. And if they have a hard time answering them, be very suspicious, and then ask them for information where you can contact them and things of that sort. That's your best way. But probably the most important part of what I just told you is you have to be suspicious when you get that call. So that scam and similar scams, what can you do to prevent? In these kind of cases, most of these are done by call. there's still a few reports of people coming to people's home and trying to solicit, charitable donations and scamming that way, but most people do it by phone. It's just too easy these days with spoof dialing. If you're not familiar with that, that's where someone can call you and make the number look like a different number. So it may look like a legit, if you looked it up, it may go back to even some kind of related to a charity of that name, but you don't know if that's really the number that called you. So with the way that they can get information online about you, specific information, from your Facebook, maybe you post on Facebook that you donated to, some kind of, veterans, charity one time, all kind of things that they can get and determine and say just the right words that make it sound like they might be legit. So most of these are going to come from the phone. So in addition to asking those questions we just said, ask questions, verify. Also do things to prevent, such as take your name off the do not call list. You can do that. There's a number for it. It's 1-888-382-1222. And you can register your number. Now that doesn't necessarily apply to charities, but it can get your number off other lists where these scammers may find your number. So that's always a good thing to do. Never give out, personal information over the phone, even if you feel like it may be legitimate and you want to make a donation. Ask them to mail you an invoice or somehow do something where you can do it in a controlled environment and what information you give them. Giving it over the phone is just too dangerous. You really, at the end of the day, you don't know who you're speaking to. If you've offered a prize, is the key. Sometimes the keywords loan, investment opportunity. These things are oftentimes keys to scams. Most people who are actually, when they're legit, they're not just calling you out of the blue. Usually that comes through some contact, some kind of organization or individual that you're related to. Those kind of keywords that sounds too good to be true, they probably are. And those should always be treated with the highest level of suspicion. Any kind of pressure tactic, if anyone's telling you they have to have the donation right now, they can't mail you an invoice for it, or you can't make it online at their website or anything like that, that's always a sign as well that that something's amiss. Any kind of pressure tactic, whether it's charities, whether it's trying to sell you something, take your time. There's no reason not to. And if they're giving you some kind of pressure tactic that this is going to, your prize is going to expire, or some bizarre, the charity's not going to take money tomorrow, anything like that, there's really no reason to pressure people, and there's no reason why money has to be handed down over a one phone call or even 2 phone calls. And there's nothing wrong with telling people that you don't do things like this until you've talked to other people and you've verified information. People who are not scammers usually are very eager to give you information you have. I'm very suspicious when charities call me, even though they sound related to charities I've given to in the past. But when I ask them questions, specific questions, I get very specific answers, and then I call, I verify, I check things out, and I think most charities that are legit would be quick to do that. So high pressure, we don't have time to verify, those kind of things should always be red flags. Don't sign any documents unless you completely understand them. And it doesn't mean you always have to take them to the attorney, even though I'm a big fan of having legal advice on any kind of binding contract or binding paperwork. But at least have someone that you trust. Some kind of person of a professional, maybe caliber, or even another individual whose business judgment, personal judgment that you trust very much. It never hurts to have a second pair of eyes on things. When you hear words that try to instill fear or try to scare you, that's usually a sign of a scam. When they talk about the next election and you're going to lose all your money, or they talk about someone that could do something, take you out of where you live and put you in any home they want to. If you hear words like that, that's a sign of a scam. There should never legit transactions should never involve fear and scare tactics of that nature. Also, another cornerstone of any kind of scam is isolation. If they're trying to isolate you from folks, if they're trying to get you to make decisions without consulting other people or without other people being involved, that's your classic, badge of fraud and scamming. So let's look at a cautionary tale or two. This one I just read not too long ago, came out of the Villages, actually, and I think this one's important to show that even sometimes when another person, maybe even a person you trust, verifies the veracity of a deal, you still should be suspicious and you should still do your due diligence. And the tale that comes from the Villages in short summary form is this. There was an investment advisor type out there who did a seminar type lunch kind of thing out there. I think he represented himself to be like a head of a hedge fund or something like that, somewhere where he's going to invest money, the Bernie Madoff kind of thing. And like Bernie and a lot of the scammers, he recognizes people are onto that. If you promise me 15, 20, 25% returns, even in a bad economy, people get suspicious now. But I think what made this one different was the fact that it had the person that was scammed out of $500,000 had been referred by another resident there, or a friend or acquaintance of some sort, who had positive results. Now, I believe that person probably had positive results. That's a classic scamming kind of thing. Very sophisticated scams. They will at least act legit to a couple of people that they think have enough credibility and wherewithal that they can find, essentially help them find victims unknowingly. So this person may have been getting great returns or being paid returns, or at least looked on paper that he was getting good returns and good investment. But that was so that the perpetrator of the scam could use that person to essentially help lend him credibility. So even if you hear about, this person had good results, they used them, it still doesn't hurt to check things out. And by the way, that gentleman, I think that was in the Villages. I don't recall the specific name, but I think they reported if you had Googled, he was already being under investigation with SEC. So just a little bit of asking could have probably found that out. So that's a very unfortunate circumstance, and I think that's a good cautionary tale to report. So in addition to knowledge and educating yourself about the latest scams, security of private information, we kind of touched on that, but you got to do that. You got to secure your information. Don't give it out. You got to check your digital and your web storage. Make sure that it's secure. Make sure you have software that prevents it from being hacked or ransomed and things of that sort. And you got to have passwords, and you got to change your passwords. I find it annoying. I hate to change passwords. I can barely remember the last one I used, but it's just, we live in an age with such sophisticated hackers and things of that sort. Passwords have to be not easy to guess, and they got to be changed, and they have to be kept secure. And finally, again, as we usually reiterate in these kind of cases, have good advisors, have good planning in place. There's nothing that substitutes for that, and doing that before you get to a point where you're vulnerable to other folks. Have good advisors that you establish long-term relationships with and that help you in your planning. That's doing your estate planning, doing your financial planning, what have you. Have those advisors, keep them advised of what your wishes are, and let them help you plan against some of these kind of events that we've described today. Well, I see we have less than 10 minutes, and I did say I wanted to leave some time for questions. Let me see if we've received any yet. Okay, I'm gonna give you, if you have a question, now would be the time to send it. While we're waiting for that, I wanted to wrap up and conclude. So I can figure this thing out. So in conclusion, as part 2 today, we looked a little bit closer at who could be liable, or who you could look at to recover if you're a victim or your client's a victim of these kind of exploitations of vulnerable and elderly persons. In part 3, the next installment here, we're gonna touch just a little bit on assisted living facilities and nursing homes, a little bit specific on those, and then we're gonna wrap back around and kind of look at at what the status of the law is now that we've kind of broken it up in pieces and looked at it, and see if we find it to be sufficient, or are there ways to improve, and we'll look and see if there's any legislation on the horizon that might change things or improve things as well. I have a question here. They're asking for the phone number again for the do not call. That number is 1-888-382-1222. It's a great resource, and I use it, and I encourage everybody to use it. All right. Well, thank you for joining us as always. If there's anything we can do for you here at Forrester Moment, please don't hesitate to contact us. My information's there on the screen you're looking at right now. Thank you again.